Good afternoon, and thank you for joining Garfunkel Wild's 2025 Healthcare Conference. As the title suggests, this panel will discuss why meaningful valuations in healthcare are absolutely critical and how to make sure that you have one. I'm Kimberly Kempton-Serra, a partner at Garfunkel Wild with a focus on healthcare transactions and compliance, and I'm honored to be moderating this session. I'm joined by two distinguished authorities in the healthcare valuation and advisory field from VMG, as well as a fraud and abuse legal expert who is one of our own from Garfunkel Wild. Thank you all for participating, and if you'll please tell everyone a little bit about yourself. Jonathan, you first.
Thanks, Kim. My name is Jonathan Helm, and I'm a managing director with VMG Health. I'm located in Dallas, Texas, and I've been providing healthcare valuation services for a little over 18 years. And over the years, my practice has really included a little bit of everything from business valuations for transaction and compliance purposes to fair value work for accounting and financial reporting and even tangible assets. But really, my primary work over the last dozen years or so is focused on contractual arrangements. So that's really anything from compensation to management agreements and really looking at the terms in those for fair market value purposes. And then my clients include health systems, for-profit, nonprofit, private equity-backed entities, and law firms.
Great, thank you. Aaron?
Yeah, hi. Glad to be here. Thank you, Kim. I'm a managing director in our Dallas office, and my professional practice focuses on, for the last 20 years, business valuation and other consulting, feasibility and other consultative services to a similar set of the healthcare services space, hospitals, health systems, outpatient ancillary providers, whether it be for-profit, not-for-profit, or affiliated with private equity or private ownership, as well as law firms. So glad to be here.
Great, thank you. And last but not least, John, and then you can kick things off.
Okay, thank you very much. So I've been with Garfunkel Wild for 17 years. In my prior life, I was a federal and state prosecutor, spent some of that time doing white-collar prosecutions, including healthcare fraud. But for the last 17 years, I've been part of the litigation and compliance and regulatory affairs, as well as white-collar defense departments here at Garfunkel. And in that context, I specialize in government regulation, government litigation, government investigations, primarily involving healthcare fraud. I do a lot of False Claims Act work, a lot of anti-kickback work, and a lot of Stark work. And as a result, I'm sort of intimately familiar with the reasons why we're here today, which is what I'll go into now. I mean, the issue of a fair market valuation is probably one of the centerpieces of a significant portion of the litigation I see under the False Claims Act, under the Civil Monetary Penalty Act. And in fact, I even occasionally handle criminal cases where fair market valuation can make or break the client's case. For example, under the Stark Law, under the exceptions, at least 10 of them include fair market value as an element of the exception. Similarly, under the anti-kickback statute, the safe harbors, many of those include fair market value as an element of a safe harbor. Even when you're not in a safe harbor or in an exception, fair market value is always relevant in defending yourself. I think, if you're familiar with the anti-kickback statute, there's plenty of law that says being outside the safe harbor doesn't mean you violated the statute. But if you can nevertheless show fair market value, it goes a long way. And finally, one of the reasons why everyone needs to understand why fair market value is important and how to get a reliable fair market valuation is because in the Stark context, you can accidentally violate the statute. So even if you believe you're at fair market value, if it turns out you're wrong, you can have liability. In the anti-kickback statute, it's potentially a crime to provide remuneration in excess of fair market value in exchange for reimbursements. So the stakes are high, and this area is one of the more important ones, and one of the ones that are, in some ways, easy to comply with, because as you're going to see, with the right people using the right methodologies, fair market value is something that can be arrived at and should be arrived at and should be on everyone's mind who practices in the healthcare field.
Great. Thanks, John. So, Aaron, with that as the backdrop, what would you say the core pillars of a defensible fair market value opinion are in healthcare?
Yeah, so appraisers, valuation specialists, however they're referred to, providing opinion services, so fair market value opinion, we're all subject to professional standards. And, if complying with the professional standards was all it took to come up with a defensible FMV, you would see a lot more of them out there. I think the way I try to think about it is the disclosure, are the disclosures adequate? So, is the opinion, is the work product itself clear on what it is, with respect to the purpose, the objective, the client. So, all things around how and why it was prepared. You can think, for example, if you're valuing business A and really the transaction involves something outside of business A, well, then that opinion starts to fall apart relative to the deal. Or if it's a compensation or other arrangement and it's referring to some, an arrangement that's not specifically the one at issue, so the purpose, the scope, the objective is one pillar. I'd say, sources of info. Is there adequate disclosure around the basis for the numbers, right? All these being, involving lots of financial and other information. Is it clear on how and where the information, the source of info? Thirdly, probably analysis. So is there something, is there a relevant and adequate disclosure around what analysis or analyses were done that sort of lead the reader of the FMV opinion to ultimately the fourth pillar, I would say, would be the valuation itself. So everything from the valuation approaches and methodologies, how that ties into the analysis, and finally, the valuation conclusion. So if there's multiple approaches considered, which one or ones were really, relied on. So.
Great, thank you. Switching gears a little bit, a lot of times when we see reference to fair market value, it goes along with commercial reasonableness. And Jonathan, can you tell us the difference between fair market value and commercial reasonableness, and when a commercial reasonableness opinion might be appropriate?
Yeah, of course. So fair market value to me is all about price. So willing buyer, willing seller, what are they willing to transact at? And in healthcare, absent, consideration of referrals. And so for a contract, that could be the rate of compensation. For a business, that could be the transaction price. So fair market value is the conclusion that we as appraisers come up with, based on informed methodologies and data. Commercial reasonableness is really taking a step back from the specific value and looking at the arrangement as a whole. So does this business arrangement make sense? Is it something that, people would enter into outside of consideration of referrals? Is it something that, is prudent and sensible? On the topic of commercial reasonableness, I know several years ago, I had a number of clients who were very concerned about physician arrangements, because that's where I, spent a lot of my time, and the financial losses that they were experiencing on, those physician arrangements. And there was a legitimate concern that those may not be commercially reasonable. And fortunately, CMS in the 2020 final rule did clarify that an arrangement can still be commercially reasonable even if you are losing money. Now, that's not necessarily a one size fits all and that always works, but it is, did put a lot of our clients at ease around that topic in particular. And then I do want to talk a little bit about, the analysis of commercial reasonableness itself. A valuation opinion is something, where there's a lot of judgment and, input methodologies by the appraiser to come to a conclusion of value. With commercial reasonableness, significant amount of information is going to come from the client. So the valuator's role, in my opinion, on providing an analysis around commercial reasonableness is to provide the framework through which the client will then provide information to allow that opinion or that analysis to be completed. So we may ask a lot of questions that address all the different elements that we believe are relevant to commercial reasonableness. Why are you doing this? What's the rationale? Have you considered patient population and other factors in this business arrangement? And get the client to provide that information. A lot of that information cannot be provided by the evaluator. We can simply assimilate it, try to check it as much as we can for reasonableness based on our experience, but a lot of it coming from the client themselves. So there is a difference between the two, and commercial reasonableness a lot of times is driven by the client and the need for the business arrangement itself in that situation. So when do you get one of these opinions? I think the first thing I would say is whether a formal third-party opinion or analysis is commissioned or whether the client looks at that internally, there needs to be documentation on commercial reasonableness one way or the other. In my experience, clients will, for simple arrangements, a lot of my clients will look at that internally. They will handle commercial reasonableness through an internal process. A lot of times it's very robust, it's very consistent. And it's similar to how we would look at it, but they handle it internally. On the flip side, I do have a small number of clients who do ask us to look at it for every arrangement that we provide a valuation opinion on. But a lot of them kind of live in the middle where, they may ask for a CR opinion or an analysis for maybe it's a new arrangement that they haven't had before. So, as an example, I had a client who began to employ physicians in a specialty that they had never historically employed physicians. And so they had a new compensation structure. It was all new to them. So we came in and provided fair market value and commercial reasonableness on that new compensation structure for this new specialty. Sometimes in complex arrangements, and by complex, that can mean a lot of different things. In my experience, a lot of times that means just multi-layered agreements. So there's an agreement with a lot of moving parts, or maybe it's multiple agreements all put together in one larger arrangement. We'll come in and provide, a commercial reasonableness assessment, in those situations. When do we provide one as a third party? It just depends on the client. But I would emphasize commercial reasonableness always needs to be documented, whether by us or by the client themselves for each arrangement.
Okay, that's interesting. Also, I just want to let you know, anyone else wants to jump in on anything, please feel free to cut me off.
So just to as you said, jump in. In my experience, I have seen relatively rare situations in which a case or an enforcement action really hinges on commercial reasonableness. It is a bootstrapping way to defend your position, but I do find that the actual fair market value is usually the point of contention when you're in either a litigation posture or a regulatory posture.
That's
The
interesting.
way of background is the difference between those two. Commercial reasonableness kind of lurks there in the background and occasionally makes an appearance, but the focus that I've seen is primarily on fair market value.
Yep. And the other thing I would add, and this may be something that everybody's familiar with, but there can be situations where an arrangement, is fair market value, but is not commercially reasonable. And that, can happen. And I mean, the simplest example that you can point to is a hospital who, pays say a cardiology medical director $150 an hour. That $150 an hour may very well be within fair market value, but if they already have 18 other medical directors in that specialty, do you really need another one? And so that there are situations where, you have those set of facts. So again, somebody always needs to look at that and be cognizant of the facts each time and for each arrangement.
So in talking about having to defend, opinions, Aaron, what would you say differentiates a strong fair market value opinion or report from a weak or a vulnerable one? And are there early red flags that professionals should look out for?
Yeah, and I'm happy to answer and really looking forward to hearing John speak on this as well, but with his depth of experience. But yeah, a strong FMV opinion would have, like I said before, adequate disclosure. There's a tendency, or there can be a tendency for in valuation to rely on information presented either by the client or obtained from other sources and not really connect it back to the facts or why it's right or why it's defensible or sort of appropriate. think in the context of a business purchase, growth percentages that really drive the value up, or productivity assumptions for a physician compensation deal that meaningfully impact the value of the arrangement, the price. A strong report will have adequate due diligence around some of those critical assumptions, whereas a weak report may be to a reader less convincing, or feel more if you wanted to make an accusation or allegation, like a rubber stamp, like that's what the client told us, or that's what the database that we pulled the source data from said. And so there is some, unfortunately, appraisers have to be the sort of the arbiter of the facts sometimes, especially if there's conflicting facts, or there's facts that are sort of in tension with one another. And I think part of that mindset of adequate disclosure is you're really navigating that in a way that the reader can understand, with a view towards explaining what difference it makes within the opinion, and where the limitations might be, or where the qualifiers might be, et cetera. And so, you read a report that sort of adequately addresses all those things, and you are able to effectively follow along with the reasoned judgment, as opposed to having, maybe more limited disclosure, sort of less, key rationale. And then you're left going, well, okay, but I'm not quite sure that I follow along, or what if that wasn't true? How would that affect things? So, and I say all that with saying it doesn't need to be, strong and weak isn't 100 pages versus 20 pages of literature. It's not about, you're not trying to create a Pulitzer-worthy, corporate fiction here. You're sort of trying to find and tell a story of either the business or the facts in a way that relates to the conclusion, and the effectiveness that's how effectively that's done, I think, makes a big difference in whether it's strong or weak.
So what I've seen, just to give you like the litigation standpoint, what I've seen as the primary areas where these fair market valuations get attacked in court are the data that's relied upon. And again, it's two issues with the data that's relied upon. You touched upon, is it coming from the client, and is it therefore suspect? Independent sources of data is often an issue in litigation. When someone's trying to challenge a fair market value, they try and challenge the source of the information as being biased, or the failure to consider relevant facts. I've seen fair market value valuation reports attacked on the grounds that they didn't properly account for the region, or for the specialty, or various, so it has to be comprehensive in addressing all the facts, and it has to be using reliable sources. And sometimes you have to rely on the client, but to the extent there's an opportunity to get an independent source of data that you're going to rely on. Those are the two things that courts seem to be easy. They easily understand if the material was from a biased source, or they didn't consider something, then I'm not going to credit it too much. It's also, one other issue is the purpose for which the valuation was prepared. If I get a fair market valuation for one purpose, particularly in healthcare, where we have special rules about not considering referrals, it may not be that valuable on another purpose.
Yeah,
on the topic of, oh, sorry, go ahead.
I was to say, Kim, we've probably been remiss in not defining FMV yet. I think, as we look towards, there's sort of, it's this arm's length hypothetical willing buyer, willing seller concept, where you're not trying to capture the volume or value of referrals or other business between the parties. I think we look to Revenue Ruling 5960, which I think has a great, it's something on order of a determination of fair market value being a question of fact, will in each case be impacted by the circumstances, right? So it's one, to John's point, where maybe an appraiser looked at the national compensation figures, market data, looked at the regional, and they were no different. But their report, because of that, they leave it out. And now all of a sudden, because it made no difference, but the report doesn't sort of go over that fact that was uncovered. And what it puts the client in a position is to ultimately on down the road, if it's looked at or put under scrutiny, you go, well, what difference would it have made if we'd have used regional? Maybe none, maybe some. And so even when it's that comprehensiveness, not in a way that's really relevant to sort of proving the point or coming to the conclusion.
So on the topic of data sources, Jonathan or Aaron, what are your sort of go-to sources that you rely on, and how do you make sure, or how do you assess that they're credible sources?
I can start with that. So let's say compensation. So we'll narrow it down to provider compensation because that's a pretty regular type of engagement that I do. There are a lot of survey sources that we look at. So MGMA has a provider compensation survey. They also have call coverage, medical directorship. AMGA has a physician compensation and production survey. Sullivan Cotter has a survey, also includes call data and physician administrative data. Gallagher has a survey. The Economic Research Institute has a survey, which is not physician focused, but it is, non-physician focused, which is helpful for some engagements. There's a small firm out of Georgia called Buckhead FMV that has a really good on-call pay survey. And then we have a number of specialty specific surveys that we may consider. So like, for example, nerves is isolated to neurosurgery specific compensation data. MedAxiom has a really good cardiology survey data. There's some online resources that are more reasonableness checks necessarily than direct data. There's a website called Gaswork that has a lot of anesthesiology, CRNA specific data. So there's a very wide range of data that can be looked at. And this is not including, internal data that, a firm like ours may have, a lot of that's proprietary. So we have to be careful how we use that, but those are other things that we can look at. The challenge with any compensation survey is that there are limitations to it. And I think it's best to address those head on than, trying to hide behind the surveys themselves. If you pick MGMA or any of the surveys that I've listed, there's some data source bias. So most of the data comes from, a select type of, there's hospital employed doctors, there's large groups, but there are going to be underrepresented parts of the physician workforce that are not going to be in those surveys. And that's a fact, but we have to, it's something that should be recognized. Sample size can sometimes be an issue in the surveys, depending on the subspecialty that you're looking at. All the surveys are going to have a data lag. They're going to be from a year, maybe 2 years ago, depending on which survey you're looking at. And sometimes, and depending on the survey and the data point that's being reported, you're going to have blended data. So you're going to have compensation reported collectively. So you may not have a breakout between clinical services versus admin versus APP supervision versus on-call. It's all going to be just put in, a collective number, which is a challenge, as you're looking at trying to address specific compensation valuations. Sometimes the production metrics in those surveys are it's all self-reported, and so they can sometimes be incorrectly reported. Maybe they're not modifier adjusted. If you're looking at work RVUs, maybe the collections include some technical, not all professional, and then there can be inconsistencies across the surveys. So are the definitions all the same? So they're not perfect, but they are generally what we have. And I will say most healthcare valuation firms, including a lot of our clients too, who employ physicians, are going to be looking at these data sources because despite their flaws, they're the best ones that we have, at the moment.
Thank you. I'm switching back to Aaron. How would you structure a narrative and evaluation in anticipation of it being scrutinized by regulators or some other third-party reviewer?
Yeah, that's a great question. We sort of, and I think many in our role, so not unique to VMG, sort of you're always prepared for that. Meaning everything you do that's an FMV opinion, you're going, what happens 2 years from now when there could be a subpoena or something? You have to produce the report and possibly be deposed or be a fact witness, whatever it might be. And so that viewpoint is sort of always present on the front end of preparing for that scrutiny. I think it's if you think through a recursive writing process, or recursive kind of, you start with an outline and you've got the standard things to, report out on. But how do you know that it all fits together in a way that really gets the point across and tells the story of, the facts and circumstances and how they relate to value? So as you kind of move through the report outline in a recursive manner, you kind of it's a dynamic process that through the engagement, you're going back and saying, okay, this is now a critical issue. This certain assumption or this certain data source is really why we are having why we are getting the conclusion at the upper end of the range, the lower end of the range, or whatever it is that is making a difference. The first time the reader of the report hears about that shouldn't be at the very end. When you think about explaining the facts and circumstances at the beginning in a recursive manner, you'd say, well, I probably ought to mention that or have that be called out perhaps where I can early on in the process. And so through a recursive sort of writing process, you're able to ensure that all of the comments and the facts and circumstances and how they tie in are really adequately addressed and sort of, so I like to say, salt and peppered throughout the report, such that there's not, you get to a certain page and you're sort of surprised at, oh, that's the first time I'm hearing about this within the report. It should really be thought of from the beginning and how it all fits together.
And this might be a good time to mention that one of the important considerations, I believe, before you actually obtain the report is how are you going to obtain it? Is the client going to hire the valuation firm on their own? And the risks there are that you don't have any attorney-client privilege. The alternative is you retain a law firm, and the law firm then retains the evaluator, and they do it under what's called a Covell agreement, which now means that the attorneys will, quote unquote, be sort of supervising the whole process. As a result, the communications between the valuation firm and the client, assuming the attorneys participating in those conversations, should all be privileged and protected in the event something goes wrong down the road. And that's in terms of, protecting yourself against scrutiny down the road, having things protected by privilege, which you may end up wanting to waive if you end up in litigation. You may end up wanting to give up everything because you have nothing to hide. But when things go wrong, having a privilege protection in your pocket is quite helpful.
And I'd add, and John, you mentioned this a little while ago about bias or the perceived bias in work product. I think we, as valuators, our professional standards, promulgate independence and objectivity. That's a requirement. And then from the ethical perspective, how do we know that we're being unbiased and we're appropriately objective when perhaps, it's the old consider the source. If you're getting data from one party with maybe it's their interest in a certain outcome within an evaluation engagement, how do you really know that? And how do you sort of buttress against that such that when you produce work product, you will your level of unbiasedness and your objectivity really shows through. So I think that's probably a pretty big deal, that inadvertently, without sort of thinking from that devil's advocacy perspective of what can go wrong or how might this be perceived on down the road, you inadvertently as an appraiser will put yourself in a position where your work product could appear biased, or at least someone could make an inference that it's got some bias in it. Always something to watch out for.
Yeah, that's actually a great segue into my next question for Jonathan. How do you ensure objectivity, especially when you're getting pressure from the client to come out with a certain outcome or value?
Yeah. So Aaron, I know would agree with me, but from the perspective of a valuation professional, from a perspective of the valuation firm, our independence and really the perception of our independence is critical, and it's one of the most important things to us. And personally, I have a lot of hospital health system clients who use me a lot for a lot of valuation work, and oftentimes, there is maybe a physician group or another company sitting across the desk from them in negotiations, and their perception of me, and rightly so, is that I'm a hired gun by the hospital, and so I want to avoid that as much as possible. So some of the things that I try to do, in those situations is, I've been doing healthcare evaluation for a little while now. And so I try to provide a reality check on the compensation terms as soon as I can to my client. So, if I get a compensation arrangement and I see the numbers, or I get a management agreement and I see the numbers, if they look to be outside of the realm of what I believe is going to be supportable, given the facts as I understand them, I try to communicate that in a reasonable way. If we're privileged, go through counsel. If we're working directly, talk over the phone, and just let them know this is what's going to happen. Sometimes that's expected, and sometimes it's appreciated. Like, okay, it's good to know that up front so we can set expectations appropriately. There are other times, and this is infrequent, but there are times that I have to say no to an engagement. I may look at the facts. I may look and say, I can't give you an opinion that is going to be credible because I don't believe in this arrangement and I don't believe I can support it. I recall, a few years ago, there was an ancillary service company that had I will call it a unique structure around management services with a number of physician-owned entities that rolled up underneath it. And when you took a step back and looked at it, we were being asked to value a very specific piece of it. But when you looked at the whole, I did not have a good feeling about it. And so, I politely had to decline that engagement. So sometimes you have to say no. But once you are engaged and once you're in the process, I think it's really important to be clear upfront with both sides if appropriate, but at least your client, here are the approaches that we're going to take. And with contractual arrangements, you're not always going to be able to use 3 approaches. A lot of the management agreements that I get, sometimes they're very niche. And so you're not going to have market comparables. So in those situations, it's good to communicate, hey, we're going to have to use a cost-based approach only because we're not going to have anything else that we can really point to from a methodological standpoint to really support a fee in this arrangement. So be clear on what you're going to use and how you're going to approach the valuation. I think then you have to be disciplined and follow through on that. Creativity in healthcare valuation is not always a good thing. And so, we don't want to come up with a new, unique valuation methodology on the fly, especially after we've already gone through the ones that we've communicated we're going to use. And so that just can look really bad. So, being very careful and disciplined on the actual application of the approaches. We then have to be very objective with the data that our client provides to us. So for example, let's go back to the management agreement where I get only cost data. There could be an incentive to provide costs that are significantly inflated. I have to be aware of that, and I have to, consider that reality. So I then have to go and look at that data with a critical eye and make sure I can substantiate it either through market checks or through, a clear understanding of how the data was derived so that I feel good about using it in my valuation. And then the last thing is, it's just sometimes you have to have difficult conversations. Sometimes we are hired to be the bad guy, and we go into the process knowing that, we're going to have to deliver bad news. There's no way around that. So to me, it all comes down to communication. And I really like to communicate to both parties, my client and the other, when I can and when that's appropriate, and be very clear up front on here's how we're going to do this. Here's the data that we need. And then just, be objective as possible throughout the process and document everything in the report.
So it's interesting you mentioned communicating with both parties. So are there times when both sides of the transaction want to kind of participate in the same fair market value opinion and benefit from it? And how does that work in terms of, who's permitted to rely on an opinion perhaps that you did for a hospital, but the doctor wants to, rely on that as well?
So I'm gonna answer your question second and answer another question first, which is when I talk about communication, a lot of times in the arrangements that I look at, I have one client, and it could be the hospital, it could be law firm, but I have one client. And when I talk about communication, what I'm trying to do is, as much as I can without giving away the result or confidential information, I want to be able to communicate, say, with the physician on the other side of the table to let him or her know, here's what the process looks like. Here's why I'm asking you for this data. Here's our valuation methodology, so that you know what we're doing and why we're doing it. Although I may not communicate with them what the final number is, because that's my client's number. But to your question directly, we are sometimes jointly engaged so that, both sides will have full access to everything, the deliverable, all communications, all calls, and that's a very common thing. The other kind of flavor of this is we're engaged by one party, but then we allow through a third-party access letter the other side to review our report, but they are not they are not able to rely on it. It's just something they're able to see for transparency purposes.
Yeah.
John,
So
John or Aaron, do you see any pitfalls in the joint engagement approach?
Well, I mean, they do present problems with what I was just discussing the last time I spoke up about the privilege arrangement, because typically the law firm is only going to be representing one of the parties to the transaction, even if the parties are, friendly and they want to work together on this. I've addressed this sometimes, but it's a little bit too much to go into here, but it does present problems when two parties want to use the same evaluator and you want to protect it under privilege. You have to be very creative, and it's not clear that you're going to be able to protect it. So that's one of the concerns I have in that scenario. It's certainly something you should make your counsel aware of. If you're intending to share the results with the other party, how are we going to do that, and how are we going to do it in a way that protects privilege? If you want to share the conversations with the other party, how are we going to do that, and how are we going to do that in a way that protects privilege?
Yeah, I would add, I think that the circumstance that Jonathan points out is, oftentimes we have a client, whether it be through counsel or directly with the end client, we're retained, and some of the data, the interviews, the information naturally comes from what is to them a third party. And so these, the physician or the business that is going to transact with our client, whatever that might be. And so they're in a position where they're looking, why is this firm asking for my sensitive information, and you're hired by the counterparty or whatever it might be. And so there's a just over the years, there's an expectation that, in those circumstances when we're having to sort of canvas a few different parties for facts and information, that there's got to be trust there, and that works to everyone's benefit. And so, if you've got if you're working with an appraiser that doesn't recognize that and isn't comfortable working in that context of sort of navigating multiple parties and still maintaining duty to client with those sorts of things, that can be an issue. And I would say on the co-client engagement, there's in this, Kim, the word right of reliance. So often our clients, the end client, doesn't really understand or appreciate the technical lens of right of reliance versus, I'm going to look at it, and if it's a good number, we'll rely on it in terms of it supports what we're trying to do. I think it's the privity of contract, right? If we have a contract, who can rely on it, who's engaging us, that we have a duty to, well, they should be in the engagement letter.
Right.
That doesn't mean that they, another party can't see the work product, but they would do that through other means, like an access letter, which is once again very common in the industry.
Okay. So there's so much more I would love to get to, but I do want to just end with, this whole discussion is about why fair market value opinions could fail, and what is sort of one overarching reason that you can think of, all three of you, that could answer that question in sort of a very simplified manner.
So from the litigation perspective, as I think I mentioned before, like I say, that the primary area of successful attack that I've seen in court on a fair market valuation is either the failure to consider relevant sources, or the fact that the sources that were considered are not reliable. I don't see as many fair market valuations attacked successfully on the grounds of the expert wasn't really an expert, they didn't use a good methodology, they should have used a better methodology. It's the successful challenges more often go to, they didn't consider this fact or that fact, or they improperly considered this fact. That's where as I see it in the litigation context, the most risk is. What do you guys see?
Yeah, well, just from my own personal experience of being, going together with clients through some sort of scrutiny, whether, whatever basis that is, litigation or whistleblower, et cetera, I'm more cognizant of the not just the sources of data, but the way I'm communicating, the words you can have a turn of phrase that is clear enough to me, but to someone that's assuming nefarious intent or some other set of facts, they might read it a completely different way. And then you're getting deposed and someone's sort of presenting you with an alternative interpretation of what's written that never even occurred to you. It doesn't take very many times for that to happen before you get very very careful. And so, what difference does that make to the overall result of, the matter, litigation, whatever it is? I don't know, but certainly as someone on the participating in it, you definitely want to choose your words carefully.
And I would say for contractual valuations, for a long time, and I would say now the environment is improving, but for a long time, there weren't really well-defined and established methodologies and standards around how to perform valuations for contracts. In the business valuation world, I mean, you have books and books and, experts that, provide, guidance on methodologies. And there's a large, uniformity around how business valuations are conducted. So what I have seen, frequently over the years that I think really creates, just a really, really, issue in compensation or other, service agreement reports is the connectivity between what you concluded and the data set you're using. I can't tell you how many times I have seen somebody pick, say, a 90th percentile compensation rate, but give no clear guidance other than just anecdotes or maybe qualitative factors as to how they got there. Or maybe they have a comp set of management fees and they pick the highest one, but there's no clear, distinction as to how I picked that one and why I picked it. And here's really the quantitative analysis that got me there. And so I think, just having a clear connection between here's how I got to what I got to based on, and sometimes a very limited data set, which is common in compensation or contract valuation, I think to me is what really can be a problem, in a report that's getting reviewed.
Interesting. Okay. Well, like I said before, I have so much more I'd like to get to, but our time is up. So thank you, Jonathan, Aaron, and John. Please join us for our live Q&A at 4:15. And thank you for taking the time to tune in today. If you missed any part of the presentation, it will be available on the Garfunkel Wild YouTube channel. Thank you.
Thank you.